and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialist. As always, I'm joined by our head of legal training, Richard Snape. Hi, Richard.
Hello, Lizzie. We meet again.
We do indeed, and we're here to talk about a case called London Trocadero Limited and Picturehouse Cinemas. Familiar couple of names. I think you've spoken to us about these before a while back, have you?
It wasn't the same facts, but they were the same businesses. Yeah, it was a post-lockdown case. So we did the first instance decision, then the Court of Appeal decision as well afterwards. Do you remember it? It was all about whether the rent should be, because cinemas obviously have suffered more than most during the lockdowns, and the fact that they were subject to mandatory closures when the rest of the country was coming out of these things, or mandatory limitations on how many people could turn up. And that case, just to refresh your memory, it's nothing to do with this one, but Picturehouse hadn't been paying the rents to Trocadero, London Trocadero, since the beginning of the lockdowns, and they made various arguments as to why they shouldn't, including things like rent suspension provisions would include things like not just physical damage and destruction, but having to shut due to mandatory closures, due to notifiable illnesses like COVID, and also tried to argue that there must be an implied term. We don't have to pay the rent if we can't open the premises, and there's a failure of basis, there's no consideration. And they failed on all those grounds. So it was a first instance decision and a Court of Appeal decision, I think in 2023, might have been 2022. But they obviously decided they didn't get on with one another, the landlord, London Trocadero and Picturehouse, and they're at it again.
So what's going on now? So it's in the High Court, and it was a judgment from the 23rd of May. So what's the current case all about?
Yeah, it's been much talked about in the legal press and the likes this last couple of weeks. It's the areas you may know. It's the Trocadero, which is just off Piccadilly Circus and Shaftesbury Avenue, named after the Battle of Trocadero in the 1820s. But I thought I'd add that. Picturehouse said, Trocadero is owned by Criterion Group, who own a lot of premises around there, the freeholds and like some over £4 billion worth of property in those parts. And Picturehouse had originally entered into a lease for cinema back in 1994, in June, I think it was, in 1994, for 35 years. And then there was another lease in 2014. And it's about insurance commissions, basically, and it's quite significant. It's a very significant decision, actually. As is the case, the norm in commercial property, the landlord would insure the premises and then recharge the tenants via insurance rent. But over the years, a practice had emerged with the landlords and brokers, insurers, that the landlord would ask the insurers to pay the brokers commissions, and they would then vastly inflate the commissions, so they'd get a large chunk themselves, and the insurers would pass the cost onto the insurance premium. So ultimately the tenants would be paying, often, I suspect, I know, without realizing they're paying. Trocadero are a bit worse than most. In this particular case, it was estimated they were making over £1 million per annum, not just on this one property, obviously, in bolstered up insurance commissions. They talked about one year in particular, 2018, where the insurance commissions were the actual insurance itself, was 79,000. The landlord's commissions were 88,000, and the broker's commission was 9,000. So you're doubling the actual level of insurance that the tenants have to pay. And Picturehouse, who are owned by Cineworld, who are the second biggest cinema chain in the world, of business in the world, took objection to this, and that's basically what this case was about.
So what did the judge say?
Well, it depends to some extent on the contracts. But in this particular contract, in this particular case, as is often the case, it said that the insurance rent would be basically an amount payable by the landlord by way of premium for keeping the premises insured. And the primary reason the judge, Mr. Justice Richards, said was, the decision was that this wasn't for the purpose of keeping the premises insured. The actual insurance premiums themselves for that. This was there to basically make a profit. So it's not commission, and it's not, so it doesn't include commission. Sorry, scrub that. So it wouldn't include commission. You can't charge for it. They went on to say that even if it was a commission, then it was basically not paid by the landlord. It was rebated to the landlord. The landlord wouldn't be out of pocket. They said that argument might just be diminished if it was stated to be payable for services, the landlord's actually placing the insurance. But so the gist of it was you can't charge these things dependent on what the actual lease and the insurance provisions say. But they put forward various other sort of little issues and arguments. They said, for instance, that the leaseholder, when they first entered into this lease in 1994, this 35-year lease, they would have agreed basically to pay this, premiums, and they wouldn't have a say. They couldn't select who the insurers were themselves. And also, unlike brokers' commissions, the landlord's commissions were optional, and they shouldn't be used as a way, unless, again, depends on what the lease says, as landlords just being able to make a vast profit out of this. And the London Trocadero tried to argue that this had been since 1994 an industry norm that was well known between landlords, and perhaps not the smaller tenants, but the large time tenants, as here is the case. That was also rejected. And so you couldn't, on this particular contract and on lots of others, add the landlord's commissions, in relation to insurance. They went on to say that they didn't need to decide upon it, but just in case they were wrong on those things, predicted an appeal, there would be an implied term that not that you had to find the cheapest insurance, but you had to find the sort of market-based insurance, as you'd find between at arm's length negotiations. It wouldn't, it couldn't be the case that the landlord could charge whatever they liked for insurance. So there must be some kind of limitation. They quoted a case called Havering Ridge and Boston Dyers from 1994 on that. So in all situations, and in this particular case, the landlord has to pay back the money. The estimate is over £700,000.
So was that the final decision then?
Well, I mean, they immediately London Trocadero basically said they're going to appeal it. So we'll have to see what happens with that. They seem quite adamant that this was a well-known industry norm, and we're going to appeal it. They couldn't believe that that's the way the decision went. The judge did point out that even if it was an industry norm now, then it certainly wasn't in 1994. There was no evidence it was when the lease was entered into. I suppose I should have also mentioned that what London Trocadero were, claiming by way of these commissions seems to have been rather excessive. It was between about 45 and 55% of the, on average, of the insurance money. There was an argument that would it be different if they were charging a lesser amount, if you like, and the judge said no, that wouldn't be the case because. This is just a contractual thing. You had no legal right to charge this money in the first place, so it doesn't matter how much you'd be charging, dependent again on what the lease says. So we'll have to wait for an appeal, but...
What do you think the implications are more broadly?
Well, I mean, it's not just this one property. Lots of tenants would not realise that that's what has been going on, not just in, sort of multi-million-pound properties and the likes either. And pending any appeal and the likes, I think there's probably quite a lot of people who could claim quite a lot of money back. And it's worth thinking about that. And again, checking the provisions in the lease and whether commissions are expressly included or sort of payments of services and the likes. Quite an important case, which is why it's been talked about a lot this last couple of weeks.
Thank you very much, Richard.
My pleasure as always, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.